Start. Learned counsel for the complainant has vehemently argued that absolutely no reasons have been assigned for discarding the injured witnesses. Full stop. The learned magistrate did not utter a single word from the testimony of the injured, which was supported by the medical evidence. Full stop. Discarding the direct evidence completely, the learned magistrate has committed a grave error of law in acquitting the accused, observing that the investigating officer was not examined, the alleged weapons used in the crime were not seized, and Section 27 of the Indian Evidence Act has not been complied with. Full stop. He would argue that the judgment written by the court is without giving reasons. Full stop. Hence, it is like a human body without a heart. Full stop. Apparent errors and illegalities are on the face of the record. Full stop. Therefore, the impugned judgment and order is liable to be quashed and set aside. Full stop. Per contra, learned counsel for the accused has vehemently argued that the non-examination of the investigating officer had materially affected the rights of the accused to prove the omissions and contradictions. Full stop. In the absence of recovery of the weapons, it would be most difficult to believe the prosecution witnesses that the injuries were caused due to the weapons allegedly used in the crime. Full stop. These two aspects were material to arrive at a conclusion that the accused were the author of the crime. Full stop. Therefore, the learned magistrate correctly believed the defense and did not believe the prosecution case. Full stop. Para. The slightest doubt in the criminal case gives benefit to the accused. Full stop. The enmity was admittedly there. Full stop. These circumstances have also been considered in the impugned judgment and order. Full stop. He supported the impugned judgment and order and prayed to dismiss the revision. Full stop. The learned magistrate in the judgment has given only the list of witnesses examined by the prosecution. Full stop. He did not discuss a single word from the evidence of the witnesses, particularly the injured, who have directly laid the evidence against the accused. Full stop. The learned judge has also recorded the finding in para 8 of his judgment that in the complaint itself, it is not mentioned that the accused, in furtherance of common intention, committed the offense in question. Full stop. In the testimony of prosecution witnesses also, it is not tried to place on record or to establish that the accused, in furtherance of their common intention, have committed the offense in question. Full stop. The learned magistrate seems to have misread Section 34 of the Indian Penal Code. Full stop. Section 34 is only a rule of evidence and does not create a substantive offense. Full stop. Para. The distinctive feature of the section is the element of participation in action. Full stop. In the case of Nandu Rastogi alias Nandaji Rastogi versus State of Bihar, 2003 SCC in bracket CRI bracket close 177, the Honorable Supreme Court has observed that to attract Section 34 of the Indian Penal Code, it is not necessary that each one of the accused must assault the deceased. Full stop. It is enough if it is shown that they shared a common intention to commit the offense, and in furtherance thereof, each one played his assigned role by doing separate acts, similar or diverse. Full stop. In the case of Sevaram versus State of UP, 2008 SC 628, the Honorable Supreme Court has held that direct proof of common intention is seldom available and, therefore, such intention can only be inferred from the circumstances appearing from the proved facts of the case and the proved circumstances. Full stop. In order to bring home the charge of common intention, the prosecution has to establish by evidence, whether direct or circumstantial, that there was a plan or meeting of minds of all the accused persons.